Hello everyone, I'm delighted to be with you today for this webinar to discuss the Hong Kong Stock Exchange's listing rule changes in relation to the exchange's disciplinary powers and sanctions, which came into effect on the 3rd of July 2021. Before I discuss the changes that I will be talking about more, I thought it would be useful to briefly look at the disciplinary structures or procedures of the exchange, the sources of directors' duties, the key obligations and responsibilities of directors of Hong Kong listed companies, and the consequences of non-compliance with the listing rules. I'll then go through the changes to the exchange's disciplinary powers and the available sanctions in detail. Under Section 21 of the Securities and Futures Ordinance, the SFO, the exchange has the duty to ensure, as far as reasonably practicable, an orderly, informed and fair market for the trading of securities that are traded on it or through its facilities. Listing Rule 2A03 requires that in discharging their respective functions and powers, the Listing Review Committee, the Listing Committee, the Listing Division and the Chief Executive of the Exchange are required to administer the listing rules and otherwise act in the best interests of the market as a whole and in the public interest. The listing rules confer on the Listing Committee certain disciplinary powers. In particular, the Listing Committee can impose sanctions that are set out in Listing Rule 2A10 for listing rule breaches on certain people set out in Listing Rule 2A09, including directors of a listed company and any of its subsidiaries. The Listing Division will initiate disciplinary proceedings by submitting a report setting out its case and all material facts and submissions on which it intends to rely to the Secretary of the Listing Committee, who then serves a copy of the report on the respondents. The Listing Review Committee acts as the final review body for decisions of material interest which are made by the Listing Committee. The review by the Listing Review Committee will be a rehearing by the Listing Review Committee on the merits. This process is aimed at ensuring that parties are given a reasonable opportunity to be heard before any final determination is made. A person that's been reprimanded, criticised, censured or otherwise sanctioned by the Listing Committee under Listing Rule 2A10 may apply to the Listing Review Committee for a review of the decision of the Listing Committee under Listing Rule 2A11. The Listing Review Committee can endorse, overturn, modify or vary the ruling of the Listing Committee. The decision of the Listing Review Committee on review is generally conclusive and binding on the review applicant, unless the Listing Review Committee overturns, modifies or varies the decision subject to review, in which case the relevant person has a further and final right to seek a further and final review of a decision by a second Listing Review Committee. The disciplinary powers and sanctions provided for under the listing rules will be discussed in more detail when I talk about the disciplinary sanctions under Chapter 2A of the listing rules. The responsibilities and obligations of directors of Hong Kong listed companies are derived from Hong Kong law, the law of the company's place of incorporation, and non-statutory regulations which include common law and applicable Hong Kong legislation, including the Companies Ordinance and the SFO. The listing rules, including the Corporate Governance Code, the Model Code for Securities Transactions by Directors of Listed Companies, the Code on Takeovers, Mergers and the Code on Share Repurchases, the declaration and undertaking which each director of a company listed on the exchange is required to lodge with the exchange, and the Guide on Directors' Duties issued by the Hong Kong Companies Registry. Under Listing Rule 308, the Board of Directors of a listed company is collectively responsible for the listed company's management and operations. The exchange expects the directors, both collectively and individually, to fulfill their fiduciary duties and duties of skill, care and diligence to a standard at least commensurate with the standard established by Hong Kong law. In addition, Listing Rule 1304 requires that the directors are collectively and individually responsible for ensuring that the listed company complies fully with the requirements of the listing rules. The directors of a listed company are also required to file with the exchange the director's declaration and undertaking in the form set out in the listing rules. This document requires the directors to undertake to comply to the best of their ability with the listing rules and use their best endeavours to ensure that the listed company complies with the listing rules. to comply to the best of their ability and use their best endeavours to ensure the listed company's compliance with the requirements of Parts 14A, that's insider information and price-sensitive information, and Part 15 of the SFO, which relates to the requirements on disclosure of interests, the Takeovers Code, the Code on Share Buybacks, and all other relevant securities laws and regulations enforced from time to time in Hong Kong. They have to cooperate in any investigation conducted by the Listing Division or the Listing Committee of the Exchange, and any director who breaches any of these undertakings is subject to sanctions prescribed by the listing rules. As I mentioned, the listing rules require directors collectively and individually to fulfil fiduciary duties and duties of skill, care and diligence to a standard at least commensurate with the standards established by Hong Kong law. This means that every director in the performance of their duties as a director has to act honestly and in good faith in the interest of the listed company as a whole, act for a proper purpose, be answerable to the listed company for the application or misapplication of its assets, avoid actual and potential conflicts of interest and duty, disclose fully and fairly interests in contracts with the listed company, and apply such degree of skill, care and diligence as may reasonably be expected of a person of their knowledge and experience and holding office within the listed company. Listing Rule 308 also requires directors to take an active interest in the company's affairs, obtain a general understanding of its business, and follow up on anything untoward that comes to their attention. Delegating their functions is allowed, but any such delegation does not absolve directors from their responsibilities or from applying the required degree of skill, care and diligence. Also, Section 4651 of the Hong Kong Companies Ordinance codifies directors' duties of skill, care and diligence, as summarised in Listing Rule 308. Section 4652 adopts a mixed objective and subjective test. That's the standard of care, skill and diligence required is that which would be exercised by a reasonably diligent person with, firstly, the general knowledge, skill and experience that may reasonably be expected of a person carrying out the functions in fact carried out by the director in relation to the company. That's an objective test. And secondly, the general knowledge, skill and experience that the director actually has. That's the subjective test. So the objective test means that a director can't simply rely on their inexperience, inadequacies, ignorance as justification for breach of their duty of care if the relevant knowledge, skill and experience is such as would be expected of a reasonably diligent person carrying out the function as a director of a listed company. The subjective test means that where a person has been appointed as a director because they have some special skill, knowledge or experience, for example, they're an accountant, then a higher standard of care, skill and diligence will be required of that director compared to directors without that special skill, knowledge or experience. While Section 4652 of the Hong Kong Companies Ordinance doesn't apply directly to the directors of companies incorporated outside Hong Kong, the directors of a non-Hong Kong company which is listed on the exchange must comply with it since they're required by Listing Rule 308 to exercise duties of skill, care and diligence to the standards set by Hong Kong law. Chapter 2A of the Listing Rules is the source of the exchange's disciplinary and sanctioning powers. The sanctions available to the exchange are set out in Listing Rule 2A10. Listing Rule 601 says that a company's listing on the exchange is always subject to the condition that where the exchange considers it necessary for the protection of investors or the maintenance of an orderly market, it may at any time halt trading or suspend dealings in the company's shares or cancel the listing. In addition to these powers, the listing rules allowed the exchange to impose a number of sanctions on directors as well as on the listed company, and these include a private reprimand, a public statement involving criticism, public censure, reporting the offender's conduct to the SFC or another regulatory authority, for example, the financial secretary or any professional body, or to an overseas regulatory authority, banning a professional advisor or a named individual employed by a professional advisor from representing a specified party in relation to a stipulated matter or matters coming before the listing division or the listing committee for a stated period, requiring a breach to be rectified or other remedial action to be taken within a stipulated period, including, if appropriate, the appointment of an independent advisor to minority shareholders. Where there is willful or persistent failure by a director of a listed company to discharge their responsibilities under the listing rules, to state publicly that in the exchange's opinion, the retention of office by the director is prejudicial to the interests of investors, or in the case of willful or persistent failure by a listed company to discharge their responsibilities under the listing rules, to order that the facilities of the market be denied for a specified period to that listed company and prohibit dealers and financial advisors from acting or continuing to act for that issuer. Under the previous disciplinary regime, where a director remained in office following a public statement issued by the exchange in the case of willful or persistent failure by a director of a listed company to discharge their responsibilities under the listing rules, the exchange could suspend or, in more serious cases, cancel the listing of the company's shares. In addition, Listing Rule 2A10 gave the exchange the power to take or refrain from taking such action as it thinks fit. The exchange brought 20 disciplinary proceedings during 2020, of which 13 were concluded by the year end. It also imposed sanctions on 59 listed company directors, of whom 30 were executive directors, 20 were INEDs, and 9 were non-executive directors. The disciplinary sanctions imposed by the exchange included public censures, public statements involving criticism, private reprimands, and statements that a director's retention of office was considered prejudicial to investors' interests. The exchange also issued directions requiring listed companies to appoint external experts to assist with internal control deficiencies and provide compliance advice on an ongoing basis, and directions requiring directors to attend training on their responsibilities under the listing rules. The exchange's proposals to revise its disciplinary powers and sanctions were first set out in its consultation paper on the 7th of August 2020. After receiving responses from the market, the exchange published its conclusions on the 20th of May 2021. The changes to the listing rules are set out in Appendix 3 to the consultation conclusions, and they took effect on the 3rd of July 2021. The exchange adopted all the proposals outlined in the consultation paper, with modifications to one. The listing rules changes have two key aims. The first was to give the exchange a range of graduated disciplinary sanctions according to the exchange, which it can impose according to the severity of listing rule breaches or other misconduct. The second was to increase the exchange's powers to sanction individuals who are responsible for listing rule breaches. In particular, the exchange will now be able to take disciplinary action against members of senior management of a listed company if they cause or knowingly participate in a breach of the listing rules or a requirement imposed by the listing division or listing committee. The relevant changes to the listing rules can be broadly divided into four main categories. First, changes to the exchange's existing disciplinary powers. Second, new disciplinary sanctions. Thirdly, additional circumstances in which the exchange can impose disciplinary sanctions. And fourth, certain minor listing rule amendments regarding the exchange's disciplinary powers and procedural matters. Prior to the amendments, where there had been a willful or persistent failure by a director to discharge their responsibilities under the listing rules, the exchange could issue a prejudice statement, referred to in the consultation paper as a PII statement. That's a public statement that it considers a person's retention of office as a director of a listed company to be prejudicial to investors' interests. Under the revised Listing Rule 2A10.4, the exchange is able to issue a public statement that, in the exchange's opinion, the occupying of the position of director or senior management of a named listed issuer or any of its subsidiaries by an individual may cause prejudice to the interests of investors. The revised wording implements 3 changes. First, the exchange has lowered the threshold for issuing a prejudice statement, whereby it is no longer necessary to prove that the relevant director had been willful or persistent in their failure in discharging their obligations under the listing rules. In practice, before lowering this threshold, the exchange didn't often issue prejudice statements, either because the misconduct, while serious, couldn't be proved to be willful or persistent, or because the evidential difficulties in establishing this behaviour was very difficult. The new wording allows the exchange to issue a prejudice statement where it considers that the holding of office may cause prejudice to investors' interests, which is likely to increase the number of situations in which a prejudice statement can be imposed. In response to comments made during the consultation, the exchange said that it will consider publishing guidance on the circumstances which may warrant the issuance of a prejudice statement. Secondly, the revised listing rule allows the exchange to issue a prejudice statement in relation to members of senior management of the listed issuer and its subsidiaries, in addition to directors. In response to market feedback, the exchange said in the consultation conclusions that it, quote, "It will not blindly consider senior management as equally culpable as directors and will assess each case in light of its specific facts and circumstances." Well, in reality, I can't see what that adds, as clearly every situation should be evaluated in accordance with its facts and circumstances. The third change says that a prejudice statement can be made whether or not an individual remains in office at the time of the prejudice statement. This allows the exchange to make a prejudice statement against directors who may already have resigned by the time the exchange brings disciplinary action. This was a problem in the previous rules, which were only limited to individuals who continued to be a director of the listed company. Under the previous listing rules, the exchange had no power to remove from office an individual who was the subject of a prejudice statement. The only course of action that was open to the exchange was to suspend trading in the listed company's shares or cancel the listing if the individual remained in office, although in practice it's rarely had to do so. So the relevant listed issuers whose individuals were the subject of a prejudice statement were not always particularly deterred from the issuance of the statement, given the lack of any immediate adverse consequences. The effectiveness of a prejudice statement as a sanction, according to the exchange, was therefore questionable, as any perceived pressure to resign was likely to fade over time. Under the revised listing rules, in cases involving more serious misconduct, the exchange is able to direct follow-on actions at the same time as making a prejudice statement against an individual. Where an individual who is the subject of a prejudice statement remains a director or senior management member of the listed company or any of its subsidiaries beyond a date specified by the listing committee, the exchange is able to deny the listed company the facilities of the market for a specified period of time, in addition to or as an alternative to suspending or cancelling the listing of the company's shares. Denying a company the facilities of the market means that the exchange will withhold its approval of any matters requiring its approval, such as the issue of new shares. The exchange has acknowledged that a denial of market facilities is a serious sanction and has noted that it will only impose this sanction where an individual who's been issued with a prejudice statement nevertheless continues to hold office. The exchange also believes that the prospect of this follow-on action will incentivize shareholders and/or the board of the listed company to decide whether the relevant individual should remain in office and encourage it to take timely action to avoid the consequences of any follow-on action. The revised listing rules provide that where a prejudice statement with follow-on actions has been made against an individual, the listed company or subsidiary referred to in the statement must refer to the prejudice statement in all its announcements and corporate communications until the individual ceases to be a director or member of senior management of the listed company or the subsidiary named in the prejudice statement. Corporate communications are defined in Listing Rule 101 to include a listed company's annual accounts, interim reports, summary financial reports, the director's report, listing documents, circulars, notices of meetings, and proxy forms. Information about public sanctions imposed is available on the Exchange's website and in the Exchange's regular enforcement bulletins, which also provide details of certain sanctions. The Exchange will also consider if, quote, the presentation or searchability of that information can be enhanced. The Exchange requires full particulars of any public sanctions made by statutory or regulatory authorities against directors or members of senior management, whether current or proposed, to be disclosed in a listing applicant's listing documents and a listed company's annual reports. There's no time limit beyond which time such disclosures would no longer be necessary, as the Exchange considers that a specified period for the disclosures would be contrary to the objective of protecting the investing public. Responding to market feedback, the Exchange did not consider that the disclosures would be an obstacle to individuals' rehabilitation from past breaches. An individual may still be appointed as a listed company director or senior management member, subject to being considered suitable to act as a director or appropriate to be a member of senior management in spite of being subject to a prejudice statement. The listing rules previously allowed the Exchange to deny the market facilities to a listed company for a specified period where its failure to discharge its responsibilities under the listing rules was willful or persistent. However, in practice, that sanction has never been imposed, in part because of the evidential difficulties involved in proving its failure was willful or persistent. Further, as the sanction could only be imposed for a specified period, listed companies had no incentive to remedy the issues which gave rise to the breach and could simply wait for the sanction to lapse. To overcome the evidential challenges in proving the culpable individual's willful mindset and ensure that appropriate sanctions are imposed in cases of serious misconduct, the Exchange revised the listing rules to remove the condition for there to have been willful or persistent failure of a listed company in fulfilling its responsibilities before it may be denied market facilities. Further, the Exchange has amended the listing rules such that the duration of market facilities denial may be dependent on the fulfillment of specified conditions. For example, the remedying of a breach of the listing rules, rather than specifying a prescribed period during which such market facilities denial would be in place. For example, where appropriate, where breach of listing rules resulted from internal control failures, market facilities may be denied until the listed company has carried out an independent internal control review and implemented any relevant recommendations, or sought and obtained independent shareholders' ratification of any relevant matter. The introduction of a director unsuitability statement to extend the scope of disciplinary sanctions available to it for dealing with more serious cases involving misconduct by directors. The Exchange introduced a new disciplinary sanction which allows it, in the case of serious or repeated failure by a director to discharge their responsibilities under the listing rules, to state publicly that in the Exchange's opinion the director is unsuitable to occupy a position as director or within senior management of a named listed issuer or any of its subsidiaries. Although the Exchange can't compel a listed company to remove an unsuitable director, such a director unsuitability statement, which the Exchange has said is reserved for the most egregious cases of misconduct, would serve to alert investors and other stakeholders of the listed company. The Exchange has adopted its proposal that the follow-on actions that apply to prejudice statements, that's denying a listed company market facilities or suspending or cancelling trading of its shares, publication requirements and enhanced disclosures that apply to prejudice statements should also apply to a director of a listed company who is the subject of a director unsuitability statement. So the imposition of secondary liability for listing rule breaches. The parties who the Exchange can sanction has been expanded with the imposition of secondary liability for listing rule breaches. Previously, the parties that could be sanctioned under Listing Rule 2A10 included the listed company and its subsidiaries, any director or an alternative of a director or member of senior management of a listed company or any of its subsidiaries, a listed company's substantial shareholder, that's a holder of 10% of the company's voting power, a professional advisor to a listed company or any of its subsidiaries, a listed company's authorized representative, a supervisor of a mainland Chinese issuer, and an independent financial advisor to a listed company. Professional advisor is defined to include financial advisors, lawyers, accountants, property valuers, and any other person retained by a listed company to provide professional advice in relation to matters governed by the listing rules. Professional advisors don't include sponsors or compliance advisors. So I'm going to refer to these people who I've just talked about as relevant parties in describing this now. However, some relevant parties, such as senior management, members of listed companies and their subsidiaries and significant shareholders, have no direct obligations which are explicitly stated under the listing rules. Also, the listing rules don't impose secondary liability for listing rule breaches. This means that people responsible for a listed company's breach of the listing rules couldn't previously be disciplined unless they were directors or another party who was subject to obligations under the listing rules. Also, no standard of compliance was set for senior management members, substantial shareholders, professional advisors, authorized representatives, and significant shareholders. This was in contrast to the standard of compliance, responsibilities, and obligations which are expected of directors of listed companies, which, as I talked about earlier, include obligations under the director's undertaking and directors' fiduciary duties and duties of skill, care, and diligence. The exchange therefore proposed that all relevant parties should be subject to secondary liability, where the exchange determines that the person has caused, by action or omission, or knowingly participated in, a contravention of the listing rules. This secondary liability is being introduced as new Listing Rule 2A10b3. Those who were opposed to the proposal to extend the imposition of this secondary liability to relevant parties were concerned about three main issues. Firstly, the legal basis for imposing this secondary liability. Secondly, the proposed threshold. And thirdly, the scope of the parties subject to secondary liability. In response to this, the exchange said that the exchange thinks that it has broad powers to make rules on matters that are necessary or desirable for the proper regulation and efficient operation of the market. Subject to the provisions of the SFO, the listing rules may govern the conduct of people with whom the exchange has no contractual nexus. Accordingly, the exchange's ability to impose disciplinary sanctions extends beyond those with a contractual nexus with the exchange to others involved in matters concerning the listing rules. Having said that, the exchange acknowledged that its authority to make rules under the SFO or make any public finding, impose any penalty or sanction or take disciplinary action under the listing rules did not extend to solicitors or certified public accountants in private practice. Those are professional parties, except in certain circumstances specified in the arrangements between the exchange and the regulatory bodies for those professional parties. Since professional parties are covered by the specific statutory regime under Section 23(8) of the SFO, the arrangements with the relevant professional regulatory bodies already set out the circumstances where the exchange may pursue disciplinary action, and the introduction of secondary liability is necessarily subject to such arrangements. The exchange modified the scope of its original proposal by including a note to the new Listing Rule 2A10b, which says that in respect of parties covered by Section 23(8) of the SFO, a sanction can be imposed under Rule 2A10b3 in and only in the circumstances prescribed for disciplinary action in the arrangements agreed from time to time between the exchange and the relevant professional regulatory body. And in considering whether a party covered by Section 23(8) of the SFO has breached Rule 2A10b3, The exchange will take into account, among other things, whether such party has knowingly or recklessly facilitated or participated in a breach of the listing rules or any undertaking given or any agreement with the exchange. The exchange believes that the inclusion of this note will ensure additional clarity that whilst the exchange is able to bring disciplinary action against professional parties in accordance with the arrangements agreed under Section 23(8) of the SFO, the introduction of Listing Rule 2A10B will not result in any widening of scope for liability beyond those agreed arrangements in respect of such parties. Threshold for imposing secondary liability. In relation to the test for establishing secondary liability, the exchange says that, quote, in assessing whether a person has caused by action or omission or knowingly participated in a contravention of the listing rules, the facts and circumstances of the matter, including the roles and responsibilities of the relevant person in question in respect of the subject matter of the breach, and also the listed issuer's rule compliance, will be taken into consideration, unquote. The exchange also said that liability for an omission will only apply to a person who has a duty to act, and that in the existence of knowledge will be relevant to knowing participation. To explain the relevance of knowledge, the exchange provided an example that if a senior management member who is responsible for a transaction has only been given limited information and enters into the transaction without knowing that the transaction is in fact a connected transaction and governed by the listing rules, that's Chapter 14, they can't be said to have knowingly participated in the transaction and be subject to secondary liability for the listing rule breach. As already mentioned, listed company directors are ultimately responsible for compliance with the listing rules and should therefore be primarily liable for breaches. Under the revised disciplinary regime, it will be possible for the exchange to impose secondary liability on listed companies' substantial shareholders, professional advisors and members of senior management, including company secretaries, who are responsible for listing rule breaches. Senior management. Prior to the amendments pursuant to the consultation paper, members of senior management of a listed company were considered to be relevant parties and were therefore subject to the exchange's disciplinary regime under Listing Rule 2A10C. However, as there were no explicit listing rule obligations imposed on and no prescribed standard of compliance for senior management members, the exchange was unable to take disciplinary action against them, even in circumstances where, in the view of the exchange, they had played a significant role in a breach of the listing rules. So the exchange considered it necessary to impose secondary liability on senior management to close what is perceived to be a gap in its disciplinary regime. The term senior management wasn't previously defined in the listing rules. Under the revised listing rules, senior management is defined at Rule 2A092C to include, it's an inclusive definition, any person occupying the position of chief executive, supervisor, company secretary, COO or CFO by whatever name called. Any person who performs managerial functions under the director's immediate authority, or any person referred to as senior management in the listed company's corporate communications or any other publications on the website of the exchange or the listed company. The exchange says that the addition of the definition of senior management is intended to capture a balanced category of individuals, so that individuals with decision-making responsibilities and or significant influence over board decisions may be held accountable. In particular, company secretaries are included within the definition of senior management, who may now be held liable for listing rule breaches under the revised disciplinary regime. Company secretaries are responsible for, among other things, advising the board through the chairman and or the chief executive on corporate governance matters under the Corporate Governance Code. Code provision F11 of the Corporate Governance Code also says that company secretaries should be employees of listed companies and have day-to-day knowledge of the company's affairs. The exchange therefore considers that company secretaries are and should be members of senior management who play a significant role in listed companies' compliance with the listing rules and corporate governance matters, and that they should be held accountable for their contravention of the listing rules. explicit sanction for failure to comply with the requirements imposed. So an express provision has been included in the listing rules to clarify that the new disciplinary sanctions available to the exchange under revised listing rule 2A10, such as director unsuitability statements, may be imposed in cases where there's been a failure to comply with a requirement imposed by the listing division, listing committee or listing review committee. The relevant requirements include those which are typically imposed on listed companies under specific provisions of the listing rules, or otherwise imposed on listed companies or individuals as a result of disciplinary actions taken. In respect of secondary liability for failure to comply with a requirement imposed by the exchange, new disciplinary sanctions available to the exchange under revised listing rule 2A10 can now be imposed on all relevant parties with secondary liability if the parties fail to comply with a requirement imposed by the listing division, listing committee or the listing review committee. The exchange clarified that secondary liability will only be imposed on relevant parties who have caused by action or omission or knowingly participated in a breach of a requirement. A provision has been included in the listing rules to make explicit the obligation to provide complete, accurate and up-to-date information when responding to exchange inquiries or investigations. The obligation will apply when quote, interacting with the exchange, unquote. The exchange said that it did not expect parties to speculate as to what information it might find relevant in circumstances where it is not asked for any information. However, the exchange noted that where a party provides information to the exchange on any matter, whether proactively or in response to an inquiry, the information provided should be as complete, accurate and up-to-date as possible. The exchange has included employees of professional advisors to listed companies and their subsidiaries as relevant parties who can be subject to disciplinary actions. The listing rules had already said, as we heard, that employees of professional advisors can be banned following a listing rule breach. In particular, a previous listing rule 2A095 said that the listing committee may ban a named individual employed by a professional advisor. The inclusion is aimed at resolving a technical inconsistency in the listing rules which affects the implementation of this sanction. Guarantors of structured products and debt securities are now also subject to the exchange's disciplinary regime and are included as relevant parties under the listing rules. The exchange has included the guarantors of structured products as relevant parties so that disciplinary action can be taken against them if they fail to fulfill their obligations under the listing rules. Guarantors of structured products are required to comply with the listing rules to the same extent as if they were the issuer of the structured products under listing rule 15A 16.3. Examples of the obligations of a guarantor of a structured product are their obligations to announce information necessary to avoid a false market in the securities, and information which may have a material effect on their ability to meet their obligations under the securities. Guarantors for any issue of debt securities are also included as relevant parties under the listing rules. The exchange has expanded the scope of relevant party to include parties who give an undertaking to or enter into an agreement with the exchange as relevant parties under the listing rules. For the avoidance of doubt, the exchange will include a clause in an undertaking or agreement where possible to alert the contracting parties and those who've provided an undertaking to the exchange that they're all regarded as relevant parties. The exchange says that this will enable it to bring disciplinary action against and impose sanctions on parties who voluntarily give undertakings to or enter into agreements with the exchange. The exchange believes that this will provide it with another forum to pursue a matter which should save it time and resources and result in a speedier outcome. There are certain minor changes to the rules. These are minor rule amendments in relation to disciplinary powers and procedural matters. The first of these is that the exchange has extended its ability to ban professional advisors from representing a specified party to allow it to ban a professional party advisor from representing any party. The Exchange acknowledged in the consultation conclusions that the ban is a severe penalty and confirmed that it will assess the circumstances for its imposition on a case-by-case basis. The second rule amendment includes express obligations on professional advisors so that professional advisors will now be under an explicit duty to use all reasonable efforts to ensure that their clients understand and are advised on the scope of their obligations under the listing rules when acting in relation to listing rule matters on which they're instructed to advise, and not to knowingly supply information to the Exchange which is false or misleading in a material particular. The third of these rule amendments is aimed at aligning the practices for filing review applications and requesting or providing written reasons for decisions. Prior to the changes, there were different requirements or practices for filing review applications and requesting or providing written reasons for decisions for disciplinary and non-disciplinary review matters. This amendment has now aligned these requirements and practices. To try to eliminate uncertainty and apparent confusion caused by different counting benchmarks, prior to the revision of the listing rules, calendar days were previously used in the listing rules as a counting benchmark for determining time limits concerning filings and responses relating to disciplinary review matters, such as the filing of review applications as well as providing written reasons by the Exchange, whereas business days were used as the counting benchmark in some other filings, for example in respect of those for non-disciplinary review matters. To eliminate the inconsistency which may potentially give rise to uncertainty and confusion, the revised listing rules have adopted the use of business day, as defined in the listing rules, as the single unified counting benchmark for determining relevant periods for filing review applications and for requesting or providing written reasons for decisions for both disciplinary and non-disciplinary review matters. As part of the Exchange's efforts to align practices for filing review applications and requesting or providing written reasons for decisions, all review applications will need to be served on the Secretary of the Listing Committee or the Listing Review Committee, whichever is applicable. The previous position was that there were different requirements and/or practices as to when the counting of the period would start relating to filing review applications and requesting or providing written reasons for decisions for disciplinary and non-disciplinary review matters. To align the requirements and practices, amendments have been made by the Exchange in respect of the counting of the time period as follows. The counting of the period for filing review applications runs from the date of issue of the decision or the written reasons. The counting of the period for requesting written reasons runs from the date of issue of the decision, and the counting of the period for providing written reasons runs from the date of receipt of the request. Finally, the Exchange made some housekeeping amendments to the listing rules specified in Chapter 7 to the consultation paper. These included removing independent financial advisors as a standalone relevant party under the listing rules and making clear that they're included within the definition of professional advisors under the revised listing rules. Also, the Exchange amended the listing rules in respect of the requirement to provide contact information for communications with regulators. It emphasised that listed companies and directors are obliged to provide the Exchange with up-to-date contact information and that loss of contact with the regulators is unacceptable. A failure to respond to and/or cooperate with the Exchange is regarded as serious misconduct, giving rise to some of the most severe sanctions. The SFC may similarly take appropriate action against those who fail to respond to its investigations. The listing rules and directors' undertaking contain clear provisions on supply of information as requested by regulators and service of notices or other documents on directors. To enhance the effectiveness of these provisions and facilitate the taking of regulatory action where appropriate, the Exchange has amended the relevant provisions so that the SFC can rely on them as well. And that brings us more or less to the end. Thank you very much again for joining me today. I hope you all have a lovely weekend.